Yes, it's been an exciting moment to be here once again as we bring you the latest jigs and the Benga news as it is hot here in Corwave TV, bordering on the social, political, and economic, of course, life of the Nigerian people. Honestly, this has fallen apart. The gods are not to blame and the center seems not to hold, and that is quite unfortunate. The lingering scarcity of fuel has become a national calamity, if I may say, or a national dilemma, which needed the most urgent attention by the federal government. Now that we have a new, of course, henchman in the affairs, piloting the radar affairs of the Nigerian state, the person of President Ahmed Bola Tinubu. And we shall be looking at the approach possibly he has been deploying in resolving these nagging issues. One of the letters is, of course, securing the interim injunction, barring the Nigerian Labour Congress and TUC from proceeding in the planned strike action against the federal government for subsidy removal. It is important to note at this time that indeed such action have forestalled or perhaps frustrated the attempt or move or plan by the National Labour Congress, of course, and her partners to embark on a demonstration strike to express their civic dissatisfaction over the untimely, of course, removal of subsidy, which has brought so much pain to the Nigerian people. Virtually everyone is affected by this uh, dilemma, of course, and people could no longer uh, wish for it to be a history. But the reality is that the approach of the government of Nigeria could that provide solution to the immediate and the medium term or long term, of course, resolution of this important national concern. It has been a recent, of course, approach of the government of Nigeria in resolving such matters bordering on labor force or bordering on the welfare of the people by rushing to the court to secure an expected order, of course, or injunction, interim injunction to forestall any action or purported action by the civil society or the labor force. This is very unfortunate that the legal, of course, the judiciary seems to have been, under this disguise, an instrument of oppression rather than an instrument of vindicating or seeking for redress for the oppressed and for those who feel uh, there have been injustice has been meted to them. But this approach have portrayed, of course, the judiciary to be an instrument of oppression being deployed by the same government who has little or no respect for several court injunctions in recent time. It is worrisome indeed to have such a move and approach by the federal government. There have been several court injunctions and rulings which the federal government has failed to, of course, adhere to. to respect such court verdicts and injunctions. But anytime they feel they want to oppress the people or perhaps stop the people from embarrassing them or seeking for redress of the injustice meted on the masses, they will rush to the same court which they have flouted its injunctions and verdicts on several occasions. What could this be? How do you see this abnormal development? And what should the Labour Congress do at this particular time? Could they, of course, approach the same court to seek for the right of every worker to protest against the injustice or perceived injustice, which more or less is affecting their service delivery and productivity? I think that should be paramount. The government should not appear to be indifferent over the plight of the Nigerian people because definitely it will affect the level of productivity of an average Nigerian worker and to such extent will affect, of course, the economic activities and the GDP sustainability of any society is anchored upon, of course, its workforce. And if the workforce have been neglected or used, the judiciary or instrument of the law is being used against them to suppress or oppress them indirectly, or, of course, gag them or silence the average workers or labor force, that would definitely amount to a very devastating effect on the economy and the society at large. Uh, does it mean that the federal government has no intention of resolving this in favor of all and sundry? Or could it mean that they are not willing to shift grounds on matters that borders on national concern? Well, time will tell what next or line of action the labor force and the TUC, and of course every other labor movement who were affected by this. It was learned that the aviation sector is also joining. The power holdings are also not left out because most factories and most industries and most offices could not operate because of inability to fuel their generators or listers. It is quite very pathetic that a country that is endowed with natural could uh, be wallowing in such a scarcity or incessant supply of petroleum products. Well, that aside, we have to look at today's uh, proceedings at the Presidential Election Petition Tribunal, where P2B, of course, scuttled the entire court proceedings by making more submissions of tendering evidence, of course, to reclaim what he called his stolen mandate. It has been admitted by the court or the judge presiding over the case. For Adamawa State, he submitted 21, of course, evidence from 21 local governments of Adamawa State. And in Bayelsa, he submitted the evidence for the 8 local governments of Bayelsa. Benue State is not left out. 23 local governments was submitted the evidence to the irregularities that marred such process. Kogi State, 21 local government documentations were made and well, of course, admitted by the court. This is very interesting and indeed becoming so interesting for that matter. Nasarawa, of course, 11 local government was also captured in the evidence tendered at the court tribunal. Niger State, 25 local government was also submitted, and on those states, about 18, as reported, of course, was submitted. 18 local government results were submitted. Sokoto, 21 local government also was captured. Delta State, 25 local governments documentations and admittance was made. It was received, of course, and tendered as an exhibit by the courts of tribunal. 25 from Delta State, as I rightly said. Imo State, 26 local government was captured. Of course, Kaduna State was not left out. 21 local government was tendered. And Oyo State, 31 local government. Wow, in total now is about 12 local governments has been submitted evidence admitted by the court and, of course, recognized as a speed for the court proceedings in defense of their petition. Well, and what the INEC legal counsel could do was just to object such submissions. Well, time will tell. But the most surprising and most annoying is that uh, the admittance of these documents was falsely submitted or handed over by the certified by INEC, the electoral umpire, before it was given to Peter Obi and Labour Party for subsequent, of course, submission or onward submission to defend or make their case. But incidentally, INEC turned out, or the legal counsel to INEC turned out, of course, to oppose the same document that was issued by them in good faith. I could be somewhat funny anyway. If in any case, uh, INEC refused to accept such documents, then INEC should be able to prove to the court that, of course, it has the gold document that pronounced this incumbent president the winner of the February 25th presidential poll. And if otherwise, of course, it should be considered as a contempt of court. If INEC could not provide the evidence to claim and convince the court that their pronouncement was in tandem with the provision of the Constitution and as declared by Mahmoud Yakubu of INEC, then I think something is fundamentally wrong, and Nigerians should be able to ask questions at this particular time. But let it not be that this is a tactical means to distract or disrupt the court proceedings, because if the court could not admit any evidence, then It could be a substantial ground of striking such petitions by as submitted by P2B, Labour Party, and PDP. That ground should not be considered at all. If INEC could not provide the evidence for the proclamation of the winner of that presidential election, then INEC should be held responsible and must be made, of course, to provide the evidence. Otherwise, uh, will be considered as an accomplice to whatever happens. And the full rights of the law should be made, of course, to take its course, to serve as a deterrence against such actions in the future. It is very necessary at this time because people are interested in the outcome of these court proceedings and wouldn't want to wait to see uh, the determination of justice and should be perceived to be fair by all. Well, of course, uh, when two people goes to court, they both know the truth, but it is only the judge that is on trial. Well, let's see how this plays out, and we are keeping our eyes crossed, and of course, watching what as they unfold, the dramas are becoming more intriguing, more exciting indeed, as a parties, the other party only objecting the uh, evidence, of course, standard, while other parties are busy getting more documentations and evidence as exhibits. Well, we hope those exhibits haven't been admitted by the judge or the uh, court of tribunal will speak, of course, and justice will be determined at the course of time. And we will continue to bring your way the latest happenings as they continue to unfold here. Don't forget to subscribe if you have not done so. Please kindly hit the subscription button. We appreciate you for watching. Please give us a thumbs up so that you can support this channel and this ministry to the next level. Love you. Have a good day.